Hello everyone, Ollamh here, and today we're going to delve into a topic that has come up on this channel recently. For a long time there has been a clash between content creators and copyright holders. Lots of reviewers have had problems with copyright claims and DMCA, or Digital Media Copyright Act, takedowns and fair use. We're going to take a look at the history of fair use today. Welcome to Geek Trivia. Let's look at some of the cases involving text. In the 1980s, Larry Flynt made some disparaging statements about the Reverend Jerry Falwell on a page of his Hustler magazine. The Reverend made several 100,000 copies and distributed it for fundraising purposes. Flynt tried suing for copyright infringement, but because the issue of the magazine was already off the market, so it was decided that it did not influence the marketability of the magazine, and therefore was considered fair use. The movie and play Hand to God featured a routine by Abbott and Costello. Who's on first? The routine in the movie is spoken between a repressed character whose hand puppet persona mocks him for pretending to be the author of the routine. This was decided to be fair use because the play and movie had a transformative aspect, because in order to get the joke, the audience must be aware of the original. Thus, it was not a replacement for the original. Now, not all cases were decided that the use was covered by fair use. For example, there was an author who wrote a book that was claimed to be a parody of Catcher in the Rye, but was actually seen as more of a sequel. The courts decided that aging the character and placing him in the present day does not add something new, and particularly that the personality remains the same from the original, therefore continuing the story rather than actually parodying the character or story. The Nation magazine published excerpts from ex-President Gerald Ford's unpublished memoirs. The publication was made several weeks prior to the date that Mr. Ford's book was to be serialized in another publication. The big point for this was that the Nation's copying seriously damaged the marketability of the serialization rights. By coming out earlier and being in publication at the same time, it would take sales away from the people who had paid for the rights. Now let's take a look at artwork, visual arts, and audiovisual cases. There was a famous case back in the 80s known as the Betamax case. This was one of the first cases where making a copy of a complete work, such as an episode of a television show, was actually fair use. The biggest point in this case is the delayed system of viewing did not deprive the copyright owners of revenue. It was seen after airing, so the ad sales for the show aren't affected. Again, marketability is not damaged. In 2003, there was a case against search engines for the use of thumbnails. The copyright holders felt that the use of those copyrighted images should have to be licensed. The courts decided that it was fair use based on the specific fact that it was a much smaller and of poorer quality. It's the facet of the amount of the item used. A thumbnail cannot take the place of a full picture. Now, on the downside, we have a case against a television news program that around 1982 copied 1 minute and 15 seconds from a 72-minute Charlie Chaplin film and used while reporting his death. The courts felt that the portion used was substantial and part of the heart of the film, meaning that by watching the news piece, there was no need to watch the actual film itself. It was not actually the subject of the story, nor was it a critique of the film. Therefore, not fair use. Now we come to the category that affects YouTube and our channel. The internet cases. In 1995, a case came about from the Washington Post using 3 brief quotations from the Church of Scientology texts posted on the internet. It was considered fair use because only a small portion of the work was used and the purpose was for news commentary. Unlike the Chaplin case, it was the direct subject of the story and very little was used. So it counts. In or around 2011, a non-profit organization posted a newspaper article about police discrimination on its website. The newspaper had sold its rights to a third party, Right Haven, who then filed a lawsuit. The court reasoned it was fair use because 1, Right Haven had acquired the rights but was not in the news reporting business, instead appearing to be in the litigation business. The second point of this case is that it was used for educational purposes, which is covered more thoroughly by fair use. Now, a case where it was not fair use. Several individuals posted entire publications of the Church of Scientology without permission. This was not covered by fair use because fair use is intended to permit borrowing of portions of a work, not the complete works. So by using the entire publication, they actually did break the copyright laws. It wasn't covered by fair use because they were trying to replace what Scientology was putting out. And now we look at one of the most recent and biggest things. This came about due to a long-running dispute over the use of a Prince song in a YouTube video featuring a dancing baby. In September of 2015, the Ninth Circuit Court of Appeals held that because fair use is uniquely situated in copyright law so as to be treated differently than traditional affirmative defenses, before a copyright owner issues a DMCA notice, the owner must make a subjective, good faith analysis regarding fair use. Furthermore, an owner who neglects to make this analysis is liable for damages for copyright misrepresentation under 17 U.S.C. Section 152F. This mentioned section deals with damages including costs and attorney's fees incurred by the alleged infringer by any copyright owner or copyright owner's authorized licensee or by a service provider who is injured by such misrepresentation as the result of the service provider relying upon such misrepresentations in removing or disabling access to the material, or actively claimed to be infringing, or in replacing the removed material or ceasing to disable access to it. Now, there are a lot of people who, before this ruling, stated that crying fair use doesn't mean anything. At that point, it was just a defense like all other cases, so not a right. But now it is a right. It is something that has to be considered, which means that copyright holders have to be very careful with how they handle potential DMCA takedowns. This is important and exclusively applied to the DMCA because in all other forms you have to go through a lawyer. With things posted on the internet, a copyright holder can have it taken down by a hosting company without any proof that the creator is breaking copyright laws, which can greatly affect the income of said creator. I feel this is the real reason behind the court making this ruling. A copyright holder can't just order something taken down without opening themselves up to being sued for damages, which is one of the major reasons that they don't push for a lawsuit against content creators. If they lose, they can be held responsible for lost wages, court costs, attorney's fees, and any other costs that came up due to the content creator having to defend themselves because of the misrepresentation of the copyright. Now, why is this a topic we decided to cover for Geek Trivia? It's very pertinent to our channel. If you remember back on August 24th, we did a review of UHF. It's a Weird Al Yankovic movie about a small TV station creating content to compete with networks. The YouTube copyright bots flagged the video right away. It was initially blocked worldwide. No strike, but nobody could watch it. We disputed it based on fair use, and it was able to be seen but not monetized while the dispute was in process. Well, September 8th, MGM Studios responded. They decided that the copyright claim was still valid. This time, they didn't block it worldwide. Anybody could watch it. They would just take the money earned through monetization. That's right. They realized that it wasn't just their movie being uploaded, so they want the money made for my review of their movie. Now we again disputed their claim. This is the point where the change in the fair use and DMCA comes to a head. From this point, in case you don't know how this whole thing works, they can do one of two things. One, they can accept that it is a fair use, which it is, and let the copyright claim expire and the video will be up for all to see and monetization will be on the video going to the content creator. Or two, they can reassert their copyright claim and issue a DMCA notice and takedown order. This opens them up to legal issues. If they don't consider fair use before ordering the takedown, they can be sued for misrepresenting the copyright. If that happens, we get a strike, which we can and will dispute, at which point they can again let it lapse, or they have to be willing to take the issue to court. I am in no way worried that they're going to try and sue me. It is clearly covered by fair use. The purpose of the piece is to critique their movie. The substantiality of the material use is rather small. The actual clips from the movie totals 13 minutes 38 seconds, or 14.4% of the movie. As far as the effects on the market value of the movie, there are parts of the movie that I leave out and don't talk about at all. More than that, though, is the fact that I point out how the movie is still relevant. Despite the fact that UHF stations are gone, if you look at YouTube channels instead, it is still very relevant. I make the point that several people will tell you that your content is no good, you'll never make it, or you just can't compete with the big budget studios. Now the fact that MGM is trying to shut down the content is such sweet, sweet irony. So there's a little peek into some of the cases of fair use, both successful and not. There are tons of cases out there, and the finer points are always being reviewed. Heck, it was only a year ago that we, as content creators, could seek damages from flagrant DMCA takedowns to make sure we don't go bankrupt trying to protect our rights. Hopefully these companies will stop, take a breath, and accept that the world has changed quite a lot, and these things have always been covered, specifically movie reviews. But now you have a lot more people creating content. The protection hasn't changed, just the ease at which someone can create a review of their movie. So what do you think about copyright law and fair use? Does it affect you, or is this just kind of a fluff piece for you? We would love to hear from you, so please leave a comment down below, send us a tweet or a post on our Facebook page. As always, thank you very much for watching. And stay tuned for more from Ollamh Productions.
If you wanna see some crazy,
Cheerio.
you should meet me and my friends. Even though we got no
See?
I know.
Yeah, maybe it's because I'm a cook. I work in kitchens. I don't know.
You would think that would shy you away.
The action and everything else. It was disjointed. It didn't quite work, as well as I think they thought it was going to work.